do it on a different day? Yeah.
Yeah.
Okay. You're Michelle Cormier?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
Right here is something most people miss, but it matters. When a defense waives a formal reading of the indictment, they're essentially saying, we know exactly what the charges are. No need to read them aloud. It speeds things up, but it also signals confidence or resignation. Either way, this case is moving fast.
Case.
Yes, ma'am.
Ms. Cormier, in clause number 25, DCCR 1446, let's see, are we going on with the prior or just the,
With the prior judge.
okay, let me, you're charged, hold on. You're charged with manslaughter from November 2nd of 2024. It's a second-degree felony. The indictment alleges you were previously convicted of burglary of a habitation, a second-degree felony, January 30th of 2013. And how do you plead to that charge? And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they've charged you with? And is that prior conviction?
And this is where the stakes quietly explode. That prior burglary conviction? That's not just background noise, it's an enhancement. In Texas, prior felonies can dramatically increase sentencing exposure. So even before punishment is discussed, the deck is already stacked.
True.
Yes, ma'am.
Okay. Sorry, it takes me a minute to get it pulled up. In cause number 25, DCCR 1447, you're charged with possession of a controlled substance, a state jail felony from October 30th of 2024. The indictment alleges you were previously convicted of possession of a controlled substance, a state jail felony, January 30th of 2013. In two different cases, or three different cases on that date. And what that means in that case is that would be enhanced to a third-degree felony. Do you understand?
Yes, ma'am.
And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And are those prior offenses true?
Yes, ma'am.
In each of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Radford?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And so there's no agreement, correct, in either of the cases. So I want to make sure you understand that you have an absolute right to have a jury come in and determine two things. The first is to determine if you're guilty or not. And then if they find you guilty in the case, you could leave your punishment up to that jury. If we go forward this way, you're leaving your punishment up to the court. And is that what you want to do?
Yes,
State tenders number 1 in each case.
No objections.
It's admitted in each case. Is there any evidence that Ms. Cormier is not competent?
No, ma'am.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to...
Notice what the judge doesn't do here. She doesn't sentence yet. Instead, she orders a PSI, a pre-sentence investigation. That report becomes the defendant's last real chance to humanize themselves. Letters, history, rehab efforts. This is where lives quietly change.
find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get a pre-sentence report done, and then we'll come back for that hearing. Anything that you think is important for me to know, get that information to Mr. Radford, and he will present it to me on your behalf when we come back.
Judge, we're gonna have some letters that I will submit to the court to supplement the PSI, and I will copy Mr. Coleman on those support letters.
Okay, sounds good. And if you'll just try to get those to the court that week before
Yes,
the hearing, that would be great.
Yes,
All right,
ma'am.
thank you. You can go back with the bailiff.
I do.
Yes, sir, thank you. All right, are you Quentin Sells? So, Mr. Rojas, you've been appointed to represent Mr. Sells. Is there any reason to believe that the person standing before me is not Mr. Sells?
No, Your Honor.
And so I'll take judicial notice of that, as well as the court's file, including a report. Mr. Sells was evaluated for competency to stand trial by Dr. Hamza. I have received that report dated November 14th of 2025. The finding is that Mr. Sells is not competent to stand trial at this time. Is there any other evidence with regard to competency?
No, Your Honor, not from the state here.
Then at this time, based on that evaluation, I am going to find that Mr. Sells is not competent to stand trial.
This is one of the most serious moments in any courtroom. When a judge finds someone not competent to stand trial, the case stops cold. No guilt, no punishment. Because the law says you must understand the process before you can be judged by it. Justice pauses here.
I'm going to order inpatient treatment at the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility, and then we'll await a report from that facility. He can go back with the bailiff.
No, go on. I'm not
We're gonna get you, we're gonna get you some help, and then you can come back and take care of your case, okay? Go back with the bailiff, okay?
Bailiff for what?
Right there, go back, go to the back, okay? Go to the, go.
It opened the wrong one in the background, that's why. Hold on one minute.
Good morning, are you Isaiah Brown? Will your client waive the formal reading of the indictment? Mr. Hoffpower, this is yours on Isaiah Brown. Okay, so it's a reduction to state jail.
Yes, ma'am.
Okay, Mr. Brown, in cause number 25 DCCR 0356, the state has elected to proceed on the lesser offense of a state jail felony, abandoning or endangering a child with intent to return from February 9th of 2025. And how do you plead to that charge? Speak up. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? Answer out loud.
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 3-year.
This right here, this is what many defendants hope for: deferred adjudication. No final conviction if every rule is followed. But make no mistake, one violation, one slip up, and that safety net disappears instantly. Freedom on a very tight leash.
Deferred probation, there would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Brown is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that we can get a pre-sentence report done by probation. Then we'll come back at a later date for sentencing. Mr. Hoffpower, what is the state's position with regard to a bond based on the nature of this plea?
We have no position.
What is the,
Just a-
what's the relationship to Kinsley Segura?
that's
Mr. Charles,
Child.
this is,
It's your daughter?
No, he's not with the mother.
I'm sorry?
They have custody I'm not sure if you, what kind of.
Do you have any kind of,
No, she blocked me when she had my baby, so I'm not on the birth certificate, I'm not on none of it.
so until anything happens legally with that, you cannot have any contact with your child, you understand?
Yes.
Okay, so what I'm going to do, based on the nature of this plea agreement, between now and sentencing, is reduce your bond in your case to $1,000. If you make that bond, it's very important that the first thing you do is go to the probation department so they can start that pre-sentence report, okay? Also, a condition of that bond is that you have no contact with Kinsley Segura, okay? And then we'll see you back at sentencing, all right? You can go back with the bailiff. Will your client waive the formal reading of the indictment? Mr. Broussard, in cause number 25, DCCR 1442, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from July 27th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes,
And are you pleading guilty because you did what they've charged you with?
ma'am. Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
We've got, it's admitted. I know, back up. Is there any evidence that Mr. Broussard is not competent?
No, Your Honor.
You need one?
Thank you.
All right, Mr. Broussard, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what is the state's position with regard to bond reduction based on the nature of that plea agreement?
Your Honor, he has a prior successfully completed probation for deadly conduct. The situation involves an in-home argument with his adult sister where he shoved her and brandished a machete. My concern would be if he was released, where would he be awaiting sentencing?
Mr. Broussard, when you are released, whether it's on a bond or when you get this probation, where will you be living?
4948 Lawndale.
And who lives there?
My mother.
Who else?
There's 2 other couples. There's Lindsay's daughter, my niece, and her boyfriend, and another couple.
Okay, where does Lindsay live?
Lindsay lives at the lake, Toledo Bend.
So you understand that you're not going to be able to have contact with Lindsay?
Yes, ma'am.
So if there's some family get-together at the house where you're living, you're going to have to leave if she comes
Judge,
over?
I do have that address as her address in my file. I'm not saying she doesn't live at the lake or whatever.
Okay.
And I'll let the court know she called yesterday, spoke with my investigator, wanted to drop charges. But because of the evidence in this case, I think I can prove it regardless. That's why we reached an agreement this morning.
Okay, so what I'm going to do, Mr. Broussard, based on the nature of your plea agreement, is reduce your bond pending sentencing to $1,000. If you make that bond, there's some very important conditions. First, the very first thing you do when you're released is go to the probation department so they can get that pre-sentence report done. If you don't do that, you run the risk of me not accepting the plea agreement. The second thing is that you're to have no contact or communication with Lindsay Gaspard. So if she is living there, you're going to have to find another place to live. You're going to have to figure that out, okay? If I find out that you're having any contact or communication, or she contacts the DA's office and lets them know that, then you run the risk of me not accepting the plea agreement. All right? Okay, you can go back with the bailiff.
Thank you, Your Honor.
Thank you.
Yes,
Or-
Judge, if we may, with the court's permission, this is basically a misdemeanor offense, but due to the nature of it, it's TDC.
Good morning. Are you Adrian Banks?
Yes, ma'am, I am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Banks, in cause number 25 DCCR 1432, you're charged with a third-degree felony offense of harassment of a public servant in count 1 of that indictment, and that is from September 1st of 2025. And how do you plead to that charge?
Guilty now.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am, I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Banks is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of, in count 1, of harassment of a public servant, sentence you in accordance with your agreement. It was 2, right? To a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also handed you a written.
And this is the part people underestimate. A felony judgment doesn't just mean prison. It rewrites your rights. Firearms, ammunition, even certain tools can now be crimes by possession alone. The sentence doesn't always end when the gavel drops.
Admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff.
Different defendants, different outcomes. Same courtroom. This is how fast justice moves and how permanent its consequences can be.